All right, everyone, welcome. This is it, your final review session for contract law. My only goal today is to make sure you walk into that exam feeling totally confident about the different types of contract terms. So let's jump right in. You know, I always get a kick out of this quote. It's a pretty funny reminder of the world you're about to step into, isn't it? A world where every single word matters, where precision is absolutely everything. And that precision really starts with the basics, the very building blocks of any agreement.
So, here's our mission for this explainer. We are going to nail down the differences between express, tacit, and implied terms. Seriously, if you can walk away from this and confidently tell these three apart, you've already mastered a huge fundamental piece of contract law.
Okay, first things first. What even is a term? It's not just some random word in a document. It's the absolute heart of the contract. It's any part of the deal that creates a legally enforceable obligation, the who does what of the agreement, with real consequences if they don't. Now, this is a classic exam trap, so listen up. You have got to know the difference between a real, binding term and what we call sales puffing. A term, like Carl having to pay for the BMW, is legally binding. But all that sales talk, this is the best coffee in the city, or this bike is the coolest in the market, that's just over-the-top praise. It has zero legal weight. Do not get tripped up by that. All right, let's start with the easiest ones, the most straightforward category. These are the terms that are sitting right there on the surface, plain as day. An express term is, well, it's exactly what it sounds like. It has been expressed. It's a clear, articulated statement of what the parties are going to do. No mystery, no reading between the lines, it's just out there. So how is it expressed? This is a super important point. Most people think it has to be in some long, formal, written document. That's just not true. It can be spoken out loud, it can be written in an email, it can even be a simple nod of your head. The method doesn't really matter. It's the clarity of the agreement that counts.
So, let's get back to our friends Carl and Graham. Carl agrees to buy the BMW for 200,000 Rand. Graham agrees to hand over the keys. Bam. Those are your core express terms. They've been clearly stated, they've been agreed upon, it's as simple as that.
Okay, now we're moving from what's clearly stated to what's unsaid. We're getting into slightly murkier but much more interesting territory here. This is where you really start to think like a lawyer.
Think about it. What about all those things that are so bleedingly obvious that nobody even bothers to mention them? Does that mean they're just not part of the deal?
And that, my friends, is where the tacit term makes its entrance. It's a term that's not said out loud, but a court will infer it based on how the parties are acting and what's going on around them. It's all based on what they must have actually intended.
Now, courts don't just go around inventing these terms willy-nilly. Oh no, there's a very strict test. The term has to be essential to make the contract actually work, it's got to be reasonable, and it has to be so self-evident that if an outsider had asked about it at the time, both parties would have just rolled their eyes and said, well, obviously. And here is the classic example, the one everybody remembers. If you buy a bull specifically for breeding, is it necessary for the contract to work that the bull is actually fertile? Yes. Is it self-evident? Absolutely. Nobody needs to write the bull must be fertile into the contract because that's the whole point of the sale. It is the obvious unsaid. And that brings us to our third and final category. Now, this one is a different beast altogether because it has pretty much nothing to do with what the parties actually wanted or intended. Implied terms are terms that get automatically dropped into certain types of contracts, not by the people making the deal, but by the law itself. You can kind of think of them as default settings that the legal system puts in place to make sure things are fair. So, how do they get in there? Two main ways. First, by operation of law. For example, when you buy something, the law automatically implies a warranty that the item doesn't have any hidden defects. The second way is through trade usage. These are long-standing, common practices inside a specific industry that everybody just accepts as standard. Okay, take a deep breath. This is it. If you remember only one thing from this entire review, please let it be this next slide. The absolute key for your exam is understanding the source of each of these terms, where they come from. Just look at how this table neatly lays it all out. Express terms, they come from the party's own words. Tacit terms, they come from the party's true, unstated intention. And implied terms, they come from a totally external source, the law itself, or trade usage. The source is everything. That's the key to telling them apart. I'm serious. Burn this table into your brain. So as you head off to prepare for the exam, I want you to start looking for these terms everywhere. I mean it. The next time you buy a cup of coffee, just stop for a second and ask yourself,
What was actually said? What was so obvious it didn't need to be said? And what did the law automatically add to our simple little deal? If you can master that, you'll be more than ready. Good luck.